Well, here's what happened. An appellate court in Illinois decided prosecutors can't use several hearsay statements in the ex-cop's murder trial. The main reason? They missed a deadline to file their appeal of the judge's decision to ban the statements by 2 weeks. The decision prevents prosecutors from presenting key statements at Peterson's trial, including testimony from his ex-divorce attorney, who said that Sabio told him Peterson threatened to kill her and make it look like an accident. Jurors also won't hear several witnesses who say Sabio accused Peterson of breaking into her home and holding a knife to her throat. Also out, testimony about other alleged domestic violence from Peterson's oldest son and second wife. The defense is calling this a big victory.
The appellate court reviewed all their arguments in regard to the merits of their claim of these hearsay statements, and they said, no, you're wrong, and we're going to let this ruling stand. There are still some of the statements that are going to be admitted into evidence if this case ever goes to trial. So hearsay is not dead. It's just been restricted to a certain degree because the judge found that these statements were not reliable.
The prosecution has said those items are crucial to their case. They're considering an appeal to the Illinois State Supreme Court. The bigger problem, it makes an already circumstantial case even weaker. Joining me tonight in Seattle, criminal defense attorney and former prosecutor Ann Bremner, and in Chicago, one of the attorneys on the Drew Peterson legal team, Joel Brodsky. All right, Joel, let me start with you. Joel, big win for you. Tell us, what does this mean for your client, Drew Peterson?
Well, first it means that we're that much closer to finally getting to trial and getting Drew back home to his children. But it also means that we won't have to face evidence that a judge, after hearing 5 weeks of testimony, ruled was unreliable. So, you know, we don't have to face unreliable hearsay at any trial, and we can move forward. And we're back where we were on July 7th of last year. We're ready for trial, and we don't have to face much of the hearsay. And they don't even have a circumstantial case. They have no physical case. They have no evidence other than other than these he said, she said statements.
Okay, but that's a circumstantial case, so they still have a case, Joel. Go ahead.
Well, circumstantial would mean that there's indirect hard evidence. Here they don't have anything. They don't have an eyewitness. They don't have a murder weapon. They don't have a murder scene. They don't have a fingerprint. They don't have DNA. They don't have, hair or fiber evidence. They have absolutely nothing. So I wouldn't even call it a circumstantial case. It was a case built on on a sandcastle of hearsay, and the sandcastle now has been destroyed. The ocean's come in, it's destroyed the sandcastle. There's nothing left.
We just heard one of your co-counsels say if this ever goes to trial, do you think they drop this case? Are they going to appeal this at this point? What happens next?
Well, they have the opportunity to ask the Illinois Supreme Court to review it. It's very, very unlikely that the Illinois Supreme Court would take this case. They only take 3 or 4% of the cases offered them, and they don't take interlocutory appeals, or very rarely would they take an interlocutory appeal anyway. Their other option is obviously to drop the case, to take not what they call a nollie process, and drop the case, that doesn't mean that Drew walks free. Obviously, there's no statute of limitations, and if they develop a case later on, they could always re-indict. But to take a man to trial in a situation where you had to acknowledge, they acknowledged a year ago when they filed the appeal that they didn't have a case that they could take to trial without this hearsay. So they've already said that they don't have a sufficient case to go to trial. To take a man to trial on the hope that, well, the jury may not like him because of his persona, so maybe they'll convict him even though there's not sufficient evidence, is simply un-American and unjust. If they don't have sufficient evidence, don't go to trial. And let the man go home. I mean, that's the system we live in. That's the greatest system of justice in the world, and that's how it should go.